KTN News at the Supreme Court, Nairobi.
Right, that's how it went down earlier on. Azimio might have lost the presidential case too lightly. What the Supreme Court found to be hearsay and, of course, unverified claims without concrete evidence, according to the Supreme Court, from descriptive words such as hot air, wild goose chase, and, of course, sensational. The Supreme Court did not have kind words for the petitioners who had failed their case at the Apex Court to challenge the win of President-elect William Ruto. Take a look.
At exactly 12 noon, the judges of the Supreme Court walked into the courtroom to issue a statement that was eagerly awaited by a country on tenterhooks, uncertainty beginning to set in.
Not a single document has been presented by the first petitioner to prove systemic ballot stuffing. A figure of 33,208 votes relied on in this claim is based on unproven hypothesis that since the number of votes cast for the president is higher than those for other positions, then, without more, it must follow that there was fraud.
11,000 polling stations that we had complained were staged were transmitted all from one IP address.
While for Azimio Brigade, this was one of their key submissions in the huge pile of evidence, believing that could anchor their case. In the judgment, the Supreme Court described it using what amount to unkind words, just hot air, sensational, and which only aimed at taking the court on a wild goose chase.
We turned to Form 34A for Gasharaigo Primary School, which was sensationally presented by Madam Judy Soweto advocate, to show that one Jose Kamango accessed the RTS and interfered with the result contained therein. This also turned out to be no more than hot air.
The dismissal of the Azimio petition did not stop there. It was just beginning. Chief Justice Martha Koome continued in the same breath in a tone and wording of her statement that remained fairly hard-hitting. Every passing minute ended Azimio's hopes of getting a favorable judgment.
INBC illustrated with examples to our satisfaction that there was no nexus between the postponement of elections and voter turnout in the affected units. Far from the fact that this claim was undoubtedly just another red herring, it has nothing to do with the question under review, and accordingly we reject it and owned that there is no proof that the postponement resulted in voter suppression to the detriment of the first petitioner.
While poking holes in the evidence that was submitted by the petitioners, the judge did not fail to reprimand lawyers who aided petitioners in swearing affidavits that they could have signed into falsehood, hearsay, and forgeries.
We must remind counsel who appear before this court, or indeed before any other court or tribunal, of the provisions of sections 113 and 114 of the Penal Code that swearing to falsehoods is a criminal offense, and two, that it is an offense to present misleading or fabricated evidence in any judicial proceeding.
The 2022 Supreme Court judgment on the presidential petition will most certainly go into history as one that was strongly worded, whose intention could be to warn petitioners and advocates to only move to the courts with strong evidence that is corroborated by proof. Some lawyers argue that this judgment has set the bar high for future presidential petitions. Brenda Zeda Radido, KTN News.
All right, away from that, President-elect William Ruto